Planned Parenthood is among the groups now asking the Supreme Court to get involved in the state's abortion fight. The new law requires abortion doctors to have admitting privileges at a hospital within 30 miles of their abortion clinic. That's already forced 1/3 of the clinics across the state to stop performing the procedure. CBS 11's Robbie Owens is following these developments and what's next. She joins us now from Dallas. Robbie.
Well, that issue, Karen, is whether an earlier injunction that blocked enforcement of some parts of that law will be put back in place while the case winds through the courts. Attorney General Greg Abbott, speaking in Dallas today on another matter, continued to insist that the restrictions protect women's health, and he says he's prepared to fight all the way to the Supreme Court to keep those rules in place. With abortion providers across the state now canceling appointments, one of those patients has joined the lawsuit to challenge provisions of House Bill 2. The 34-year-old Austin woman says she was scheduled to have an abortion on Friday.
We can barely afford our own health care, let alone a child. We decided that we want to start a family someday, but that we just can't do it right now. Because of Thursday's ruling, that decision was taken out of our hands.
A group of Texas healthcare providers sued earlier this year to block enforcement of a provision requiring abortion providers to have hospital admitting privileges within 30 miles of the clinic. Last week, a district judge agreed, calling the provision unconstitutional and issued an injunction stopping enforcement. Days later, the Fifth Circuit Court of Appeals reversed that decision, and the new restrictions took effect immediately. The move forced more than 1/3 of the state's abortion clinics to stop performing the procedure. Texas Attorney General Greg Abbott says he is encouraged by the Fifth Circuit's ruling as the case winds through the courts.
Ever since Roe versus Wade, the United States Supreme Court has been clear that states have a legitimate state interest in protecting the health and safety of anyone involved in the process. And that's exactly what the state of Texas did here.
Reproductive rights groups insist that the admitting privileges provision does nothing to protect women's health.
If the point of this is to keep women healthy, taking a safe and legal option away from them and encouraging some women to do something unsafe is the diametric opposite of what we're purporting to do here.
The state has until November 12th to respond to today's filing. The Supreme Court is expected to weigh in quickly thereafter. Live in Dallas, Robbie Owens, CBS 11 News.
Thank you, Robbie.